is Water Rights Manager in the Water Rights and Contracts Department at Salt River Project, where he manages various aspects of the protection of SRP. And SRP stakeholders' interests in Arizona general stream adjudication and other water rights achievements, managing an excellent team of water rights analysts and overseeing the day-to-day efforts, technical analysis, products of these employees. Prior to becoming manager of the water rights at SRP, he was a senior water rights analyst where he performed analyst research and stakeholder engagement that focused on protecting the water rights of SRP stakeholders. He started out at SRP as a senior GIS analyst for the SRP Cartography and GIS Services Department. The Salt River Project was first multipurpose water and electricity federal reclamation project in the United States and is the largest provider of water to the Phoenix area. He's lived in Arizona since 2008. While living in Flagstaff, that's closer to us, he obtained an MBA at Northern Arizona University. Prior to moving to Arizona, he worked at the GIS analysis for Utah Geological Survey in the Department of Natural Resources. Most of his work at the UGS involved GIS analysis of geographic hazards such as landslides and earthquakes. He also worked as a GIS foreman for Osmosis Utility. I don't think I said that right. Okay. On contract with Pacific Corp and Rocky Mountain Power. In 2001, he worked for the Lands and Realty Division, what do you know, Realty, of the Bureau of Land Management, Utah State Office. Here you go.
Great. Thank you, Esther. You got the extended version of the introduction, so I appreciate it. Well, thank you. It's a pleasure to be here today. I'm going to pace a little bit, and that's kind of what I like to do, so forgive me if I'm a visual distraction. I'll try and keep it to a minimum. But I do want to thank Esther Talbert for having us out here today. I think the first one of these that we did for Sedona Verde Valley Real Estate Association was probably about 5 years ago. And at that time, I think we fit into the divider, the first divider of this section. So it's good to see that we've grown our ranks and that there's a lot of people really interested in learning about the water issues. What I've said before to others is that there's a lot of people with a lot of water expertise and knowledge in Arizona, but not all of us know all of it. So your questions are really challenging and difficult sometimes. One, because of the complex nature of the issues, and two, because we specialize in different areas. So we'll do our best to try and answer some of those questions, but just know it really takes a lot of these kind of meetings with a lot of different kind of people that have expertise in different areas to fill in the water picture for both urban Arizona as well as rural Arizona. So we've tried to focus our presentation today on what's relevant to rural Arizona, what is relevant to the Verde Valley area. I've been working in the Verde Valley community for about 10 years now. I've started coming up, meeting with individual landowners, talking with city officials, city employees, town employees, working on water issues to try and find solutions to, frankly, complex challenges and issues and complex issues. I do want to mention one thing about this last slide that Carter presented on, which is really a timeline of what we can expect in terms of the adjudication as it relates to the Verde watershed. For many years and decades, the adjudication was progressing very slowly in the San Pedro River watershed. It's really just within the last 5 to 6 years when things have accelerated in the Verde watershed. And now we have real dates on the calendars when we can begin to expect the adjudication to reach the Verde Valley. So what seemed like the thing that was so far off, you didn't have to worry about it anymore, is now it's now much closer to reality. And even though these timelines look, several years off, and sometimes those deadlines get extended. It's now a present thing in the Verde watershed, so I want to emphasize that. The other thing is, what we've experienced in the San Pedro watershed is as we've adjudicated water rights down there, what seems like a very contentious, challenging, lawyer-driven process for most small claimants is proving to be a not lawyer-driven, not difficult, complex process. For most, that's not the situation for everyone. And the larger the water use gets, the more complicated it gets. Many times we end up working with claimants to identify and provide information that will at least not challenge the water use that's that's taking place. Can't always do that. If there's no documentation that exists, then we can't help and provide that information. But what we do try and do is, if we can work with a landowner, we can work with an entity on coming to a resolution, we can end up stipulating to work with those landowners to get their water rights put into the catalog for the certainty that adjudication brings to all water users. So yes, it seems like a contentious process. Yes, there are attorneys involved. For many landowners in the San Pedro watershed, they've actually found it to be a process that they can navigate themselves, or with with some assistance from legal attorneys representing them. I do want to talk about, so my portion of the presentation is really about the issues that are associated with this region, as well as other regions that have an impact on the Verde Valley and Sedona. I want to talk a little bit about what's going on in the upper Verde watershed. So this is the area above Clarkdale, above the Verde Canyon area. Maybe you've taken the train ride up Verde Canyon. We want to talk about what's going on in the Big Chino and in the Prescott area. Most of us are downstream from those communities as well. Those communities are growing significantly. They're also having water challenges and looking for water supplies. So what are we doing to work with those communities to ensure the health of the Verde River, at the same time as see if we can help address those water needs in that area as well? So I'm going to talk about the Big Chino monitoring and modeling project that we are we have an agreement with cities of Prescott and the town of Prescott Valley. So what is the Big Chino Subbasin Water Monitoring Project? In 2009, the city of Prescott indicated its intention to begin plans to export water from the Big Chino aquifer, transport that water to the Prescott Active Management Area. They entered into an agreement with Prescott Valley to help fund that pipeline project. That pipeline project would move 8,068 acre-feet of water from the Big Chino Ranch to the city of Prescott and Prescott Valley. SRP took issue with that because the Big Chino aquifer is the headwaters of the Verde River. I'll show a picture of that in a second. And we wanted to ensure that the headwaters of the Verde River were not impacted by this proposed project from those communities. We, after some period of litigation, we resolved our disputes with agreements in 2010 and 2012 to put into place a monitoring and modeling and mitigation plan. We call them the 3 M's. They're sometimes hard to get out of your mouth. So here is the Big Chino aquifer. You can think of the Big Chino aquifer as really kind of a bathtub of sorts, where you have kind of 2 main inputs into the bathtub. You have Big Chino Wash, which flows from north to south and joins up with the Verde River right in the Paulden area. And then you have Williamson Valley Wash, which kind of flows south to north and joins up with the Big Chino Wash in about the same area. This the area where the Verde headwaters is, that's the source of the Verde River. That's where the Verde River starts. Here is what Big Chino Water Ranch looks like. This is the area that Prescott has plans to pump water from the Big Chino Water Ranch and transport that water via pipeline to the communities of Prescott and Prescott Valley. This is what the ranch looks like today. You can see it's on a broad, flat plain, alluvial aquifer, and home to many species like pronghorn antelope, elk, those kinds of things. It's an area called a grasslands of national significance, I think is what it's called, for its unique character as a range for those species. It has been farmed for many years and has drawn down the water table in that area already. But there is water in that aquifer, and that is the water that Prescott and Prescott Valley would like to have access to. The Big Chino Wash is the basin that feeds the Verde headwaters. These are the Verde headwaters. These are where the springs originate that supply water to the Verde River. So the Big Chino Subbasin Water Monitoring Project was kind of consolidated or formalized in what we call Comprehensive Agreement Number 1. This is an agreement between SRP, Prescott, and Prescott Valley. It has three main points to it, which I've mentioned already. The first one is monitoring the hydrologic conditions in the Big Chino Aquifer. What are the flows in those systems? What are the precipitation events in those systems? What are the groundwater conditions in that basin? The second one is modeling, taking that information from the monitoring program, putting it into a groundwater model, and then running scenarios on that groundwater model to help you understand what the impacts are going to be with those development patterns, with those pumping plans. What are the impacts going to be on the Verde River? If there are impacts, they will be known before the pumping occurs, at which point those communities have an obligation to mitigate for those pumping impacts. So it says if necessary, it's likely going to be, there are going to be some level of impacts we don't yet know. We're waiting on the modeling work to finish with the monitoring work that the modeling work that is being done right now. So here's some examples of some of the monitoring work that's taking place. One of the important things that feeds into a groundwater model is an estimate of the recharge that's taking place. That's why these data collection efforts are so valuable and critical. We've come up with some pretty innovative technologies to do this work. We've employed cameras in the field to measure what the flow stage is, or how much water is flowing in washes. We've put in a lot of instrumentation there, and really a lot of it is geared towards coming up with the graph on the right called a hydrograph that indicates what the flows in those washes have been, so that we can do things like estimate recharge. Again, that goes into a complex groundwater model. The purpose of that model is to model the movement of water in the Big Chino Aquifer. How does that move through the underground geologic units within the aquifer, and then match what is observed hydrology with, have the model match observed hydrology, and to model future hydrology that passes any indication of the future. And again, it's to determine ahead of time if mitigation will be needed and what that mitigation will look like. Where should that mitigation take place based on where you anticipate the effects of that pumping to occur? And then again, you run modeling scenarios on the model to say if the water is pumped from this area at this time in this quantity, what is the impact? so that you know where your mitigation efforts need to take place and to what extent do they need to occur. So what are some of the options for mitigation? How could you mitigate some of the effects of a groundwater importation project like this? There are a few ideas. These are a few that were brainstormed by a stakeholder group. Not necessarily a comprehensive list, not necessarily SRP's list, but just some of the ideas that were envisioned as part of what you could do to mitigate for the effect of groundwater pumping. The first one is retire historic agriculture in those areas by removing an existing water use. You could mitigate for future pumping. The second one is conservation easements. If you apply conservation easements, that land won't have any future water use associated with it. Some of that could be used as mitigation for a project. Manage recharge. There may be some opportunities to do things like slowing down the effect, or slowing down the rate of water flowing in washes so that it helps the base flow of the river during times when water isn't flowing in those systems. So if you manage the recharge, if you manage the recharge that's flowing in the natural course, then you can improve the base flows during those critical times that Carter was talking about, in those June low flow months, those months where the river is at its critical point. And other ideas, I think this group is open to other ideas and solutions that may not do some of these things. Demand management may be an additional idea on what you could do to mitigate the effect of future pumping. So there's a whole group that's kind of working on what these mitigation options could be. I do want to kind of bring us back to some of the major issues facing the Verde Valley. We spent a lot of time talking about unadjudicated water rights, what that certainty means, and what certainty is needed for everyone to make better informed decisions. I won't belabor that, but just know that it's one of those main issues that we really want to see movement on and continued emphasis on through adjudication. Groundwater withdrawals, it's no surprise that groundwater withdrawals are a major issue facing the Verde Valley. We acknowledge and know that growing communities need water. There's a lack of groundwater regulation in rural Arizona, and there are some areas, they were discussed earlier about active management areas and irrigation non-expansion areas. Those are two tools in the toolbox. What is likely going to be effective for rural Arizona may be something different, like a management area of local design, of local input, locally managed, local solutions. So that's something that really can help address some of the issues that rural Arizona is facing. A lack of data. We've talked about how it's not well reported on what water uses are actually occurring. I'll say again, we don't have any desire to meter every single well in the Verde Valley. It doesn't make sense. It doesn't make sense to meter 10,000 wells if 9,000 of them show you use about half an acre foot per year from a domestic well. It doesn't make a lot of sense. Where I think you will see a desire for more metering is for larger users, your municipal users, your large agricultural users perhaps, if there are a regional water management area. And I'd say few tools for rural communities to transition from surface water irrigation to domestic water uses. This is how the Phoenix metro area has grown. We've transitioned from an agricultural use to an urban use, and while doing that, maintain the water rights associated with that. That's something that's difficult for rural communities to do because the tools available, and what I mean by that are the sever and transfer tools, where you sever a water right from one use to another use, or the change in use tools, aren't very well understood, aren't very well used, and are frankly difficult to get approved by the regulatory agency that reviews those. So there needs to be some movement and improvement in those areas so that agricultural areas like the areas under irrigation ditches in Cottonwood, like the irrigation ditches under Camp Verde, as those urbanize, or if they urbanize, not assuming they will, if they urbanize, how do you take the water use associated with those former uses and then make it part of the water supply portfolio of those communities? The top two items are really kind of policy related issues. Where I wanted to focus our attention today, where I think is important to you guys, are the real estate transactions. These are something that you guys probably deal with day in, day out, have a lot of input and control over. So this is really where I wanted to spend a lot of time today. We know that there's often questionable assertions about water rights as part of those real estate transactions. We hear about them sometimes. Someone will call us and say, hey, do you have information about water rights? I'm being told by an agent that I have grandfathered water rights. I don't know what that means. And do I have what the potential seller is telling me that I have? So we know that that's kind of an issue amongst the real estate community. Outdated water right filings. Most of the water right filings, the statement of claimants, the statement of claim forms, a lot of those were produced in 1974, 1978, 1980s. A lot of them are outdated. They haven't been assigned to the new landowners. They haven't been kept up with the chain of title as it's gone from one landowner to the next. As the adjudication comes, those are all going to need to be updated, or new statement of claimants need to be filed. So a question was asked earlier about, can you still file statement of claimants? Yes, you still can file new statement of claimants. Keeping current old statement of claimants is also part of that process. So you may be part of a real estate transaction where you're getting old statement of claimants or old water right filings or old well registrations, and you need to put that into the name of the new owner. Those are all important things that will help make the adjudication go smoother for that landowner. So I want to go through a hypothetical case scenario that kind of outlines what some of these issues are that we sometimes see as people call us and ask us for water right information. How does it happen where landowners get into a situation where they may find out later on they don't have the water rights they thought they had at the beginning of the real estate transaction? So you have a creek flowing peacefully down the course and stream. The land is settled on. So this land, in this case example, was settled in 1895, 75 acres of land. They went to the county and recorded what's called a notice of appropriation in 1898. Notice of appropriation was really a statement that you made with the county that says, I intend to put water to beneficial use, and I'm going to post this notice on a tree where I divert water from the creek. They then built a ditch to begin serving water to the land that they settled on. They then began using water on, let's say, 30 acres, and that land, probably started at 20 acres and then expanded to 30 acres between 1895 and 1919. So far, to this point, we are all legal and good. That landowner is fine to this point in time. After 1919, they expanded water use to 15 acres. 1919 is an important date because it's the date of the State Water Code. The State Water Code said if you're going to appropriate new water, you need to apply, obtain a permit, and get a certificate of water right for that use. Not every landowner did that. Not many landowners did that. They just put the water to use, expanded that use, so that's why it's kind of colored in orange there on that map. Well, at least you only have one property that has an issue to this point. Along comes the adjudication in 1974, And you had to fill out forms as part of the adjudication. There's a form called a Water Right Registration Act filing. It's also called a 36 filing because that's the prefix number for it. That landowner said, I'm going to claim 45 acres because that's what I'm irrigating today, and it's pre-1919, and I'm going to claim 10 acre feet per acre for a total of 450 acre feet. Oftentimes there wasn't documentation showing how that quantity was calculated. The basis of claim references the notice of appropriation as the basis for the right, and they may even provide deed records and land patents to what they're claiming today. Well, we created another problem. The land was subdivided in 1980 into parcels A, B, and C, and the water right filing, in this case, did get updated, did get assigned to the new landowners. You have one landowner that got 225 acre feet. You got another one that got 225. And landowner C didn't get any because he doesn't have any irrigation taking place on his property. But he kind of wanted to start using water too. So he files a new claim for 40 acre feet on 25 acres because that's the size of parcel C. And he says, I only want 8 acre feet. I don't want 10, I want 8. And then they expand their post-1919 water use without going through the process to obtain a water right. And parcel C is marketed as having 25 acres with 40 acre feet of pre-statehood water rights or grandfathered irrigation rights, or you name the colorful term of art. From Wet Creek. So they filed a new claim as well. So who now has an issue with their water rights? Parcels A, B, or C, or all of the above? All of the above. So this is how we get into these situations where, and I say this is like a worst case scenario, but it's indicative of the kinds of things that we see come through when people have requested of us information about water rights. What we would tell someone when we get that inquiry that says, hey, I'm interested in purchasing a property, can you tell us what parcel A has? Well, we would tell them what the green area for parcel A is. We would tell them what the green area for parcel B is. And then we leave it up to the landowner and the agents to make informed decisions and consult their clients accordingly. So that's why it's important to reach out and get good information about the particular transactions that you're involved with, and seek out the best information available for your clients. I want to talk about a couple of efforts that we're involved with to kind of address some of these issues of expanded use. The first program that I want to talk about is what we call our Verde Valley Water Rights Program. SRP purchased 2 farm properties in the Camp Verde area, one in 2015 and one in 2019. These properties provide 177 acres of water rights, and the purpose for these properties is to resolve local water rights issues, probably starting out on the ditch that serves these areas. That happens to be the Verde Ditch in the Camp Verde area, but it's really intended to resolve issues throughout the Verde Valley, but starting on the Verde Ditch. These properties also have development potential and conservation values, some habitat for important species. We started our public outreach about these properties in the fall of 2020 and 2021. We're currently in the process of getting the water rights filings, paperwork transferred over to the name of SRP, getting those claims updated so that we can start doing things like sever and transfers. We also want to work out the sever and transfer process so that when we go approach a landowner that says, hey, I think I have a water rights problem, I'm looking for a solution, is there water rights available through your water rights program? We can tell them confidently, yes, we think we can help you, and we if we put an application to sever and transfer water rights to the Department of Water Resources, then we have a reasonable expectation that it'll be approved and granted for that landowner who wants to resolve those issues. Some key points about this program: water rights remain in the Verde Valley. This is intended to be a local solution to address local issues. This is largely in preparation for the adjudication, when a claimant will need to demonstrate that they have a historic beneficial use or water right obtained through a sever and transfer. It's also an alternative solution to litigation that achieves a positive outcome. If these were litigated, you might end up with resolution to the issue on a legal standpoint, but it doesn't make the user whole. This is a solution that makes the user enabled to keep doing what they've been doing. So I also want to talk about another thing that we have that we've been working on with individual landowners. It's what we call Verde Valley Historic Water Use Agreements. Not everyone is in a situation of expanded uses. Not everyone has a water rights issue. If we look at a property and a landowner approaches us and says, hey, I want to know if I have an issue, and we say, no, it actually turns out that your water use is associated, is recognized, and is largely in line with what we see in our historic documentation, we're willing to enter into an agreement with that landowner that says SRP recognizes your historic uses, you recognize SRP's uses in the area that it serves, and we'll agree not to contest each other's rights in the adjudication. So this is a pretty good opportunity. We think this adds value to real estate transactions. We think what we've seen from title companies is that they have seen these and they've asked us, what is this? I haven't seen many of these before. What are they? And we can then educate the title companies on what it is. They've told us that they like it because they get asked questions about water rights, grandfathered rights all the time, and they don't know what to say. So having something in, it also gets recorded with the county so that it shows up in a title search for that property. So it's, we think is a good alternative or a good option for those water users that don't have any expanded use issues. So what does that historic water use summary process look like? What do we look at when we look at historic uses? This is an irrigation survey from 1920. It largely identifies the historic uses that were taking place at the time of the state water code. It's really helpful in identifying and determining where those historic uses were taking place. We'll then bring that information into our geographic mapping system to delineate those areas. We'll use aerial photography to match what was taking place at the time with those boundaries to make sure that the survey is reflective of what was taking place. And then we'll overlay it on today's imagery with today's parcels. Let me see if oh yeah, there we go. Today's parcels to determine where these areas of historic use are. This helps inform the historic water right agreement, historic water use agreement process. It also helps inform when somebody calls us and says, what do you have about historic uses? What information can you provide? We'll prepare a summary that looks at it on a parcel basis, says the number of acres, and says how much historic use is in that parcel. And sit down with a landowner, sit down with an agent sometimes, and have this conversation with those landowners or share this information with them. We can't always provide this information. There's certain circumstances that we're not able to share the information due to kind of the legal setting right now, but oftentimes we can, and we're willing to have that conversation. So what the historic water use agreement says, it recognizes historic water use that are either pre-1919 uses, post-1919 uses with a certificate, or water rights that have been transferred. It recognizes the area or the acres of historic water use. The parties, again, agree not to contest the uses in the adjudication, and it also allows for future water right transfers. It doesn't preclude them. This agreement, again, is recorded with Yavapai County showing up on future title searches. What the agreement does not say, it doesn't require or mention water metering or reporting, it doesn't address water quantity, it doesn't address priority date, it does not prohibit or limit the use of well or other water sources on historic water use lands, on those lands with historic water use. If the parcel's split and it has historic water use on some portion of the property and it doesn't have historic uses on the others, it does prohibit the use of water on that land that doesn't have historic use. SRP's stewardship role, as Carter mentioned, doesn't begin and end with water rights adjudication or water rights administration or water rights conversations like this. Our stewardship role goes beyond that. We're heavily involved in forest health and watershed health efforts. This can range from an extensive stream flow monitoring partnership with the U.S. Geological Survey. A lot of the data that you see when there's high water events, when you see flows on Oak Creek or flows on the Verde River, flows at lower Camp Verde, those are partnership gauges that SRP has with the U.S. Geological Survey to know what is flowing in the Verde River. The other thing that we're heavily involved with is Forest Health Initiative. We're working with partners to help fund forest treatments up in the upper ends of the watershed to help bring those forests back to a more sustainable and healthy forest. Our forest management policies over the last century have really allowed our forests to be filled in with a much more dense tree canopy than they were historically. Restoration or forest restoration is really about restoring those forests to a more natural setting where fire is a natural portion of that landscape. So it's really getting in, thinning those forests, and then reintroducing things like controlled burn in those areas to improve the watershed health. It's not just about water quantity, it's also about the quality of water that's flowing, and forest health treatments and those kind of things improve the water quality. So it's not just about quantity. I think I've covered a lot of ground, but that's what we've had. Carter, come on up. We'll be happy to address any questions. Esther, is now the time to do that?
Yes, we've got kind of a dual thing going on.
Okay.
First of all, Michelle's going to pull up. I think we had 7 or 8 that texted 928-900-3506. We'll try to do that intermittently. And then if you can take the, let's see, do you have we need to get enough microphones. Yeah. Okay. We've got one here.
I'm going to make one pitch. And our good friend Carter Benton was kind enough to bring these 2 documents. There's a stack of them on the table as you leave. They're really about, one's called Evaluating Surface Water Filings in the Verde Valley. The other one is called Understanding Surface Water Rights in the Verde Valley. Locally geared, it's produced by the Nature Conservancy, SRP, Yavapai Apache Nation, and various other groups. Pick these up as more information material about water rights in your area.
Thanks.
That's my plug.
But Lucas, we work together. We're not friends.
Okay, do the next one real quick. Okay, what is the difference between ground and surface water rights? How do you prove your well is groundwater and not subject to surface water rights? I don't know who said that one. Are they still here? Okay, would you stand up? Okay. Which one wants to answer that?
So it's a difficult question, which is fine. I think what the question is what will the court determine between groundwater and surface water? the court has said that if you were within the subflow zone boundary, that map that was on Carter's presentation earlier, you are presumed, if you have a well, you are presumed to be pumping surface water. If you are outside of that boundary, you may also be pumping surface water if your cone of depression, as determined in a test, touches the subflow boundary. The cone of depression you can think of as if the water level started here and you began pumping, there's a cone that forms around that well casing, and it then draws down the water the further away it gets. And if it touches the subflow zone, then you're presuming to be pumping a portion of surface water. There's another test called the depletion test that determines what percent of surface water you're drawing from that zone and what percent is groundwater. That's why it's a complicated question, because you can have a well that has both surface water and groundwater component to it.
Okay, next, I'm going to have Linda get somebody standing up in the audience. It's next.
My question was about people who like a larger ditch association, like the Cottonwood Ditch Association, and they have a share in that association. Do you have to file separately as an individual?
So the question is does a share in a ditch association, I'm going to frame it a little bit differently. Does it constitute a water right, and you have to do anything different associated with it? I think I heard a question earlier, do you have to file your own claim associated with it? First of all, I'm not an attorney. I can't give legal advice, so what I'm going to say is what most people do in most situations. Ask others who are attorneys, maybe. Yeah. So a ditch share, in most cases, is your responsibility of maintaining that portion or share of the maintenance and ongoing operations of the ditch. It doesn't by itself constitute a water right. Water rights are pertinent to land. So if that land has water rights, that's the source and nature of your water right. It's not by virtue of the paying of the ditch share or the ongoing paying of the share. It's not bad historic documentation and good information to include if you were to file your own statement of claim, if you were to file your own paperwork in the adjudication. Not all users file their own statement of claims. The ditch, in most cases that I'm aware of, the ditch or the irrigation provider has filed on behalf of its users. Many users end up wanting to file on their own behalf to represent themselves. Probably not required, but a lot of people want to do it in order to kind of control their own fate, if you will.
Next, I'm just going to put a little pitch. Actually, the PowerPoint I created, we have all the ditches. There's about 25 ditches. And I took that from some of the title company stuff, some old stuff I had, and from Arizona Department of Water. So that will be available to you, so you don't need to worry about it. SVVR will send you that PowerPoint. There are hot links in there. One of them is where I took a lot of that information from Arizona Department of Water. And they historically, I think that was created in 2000. I don't know if there was an update. I asked them, I haven't heard it yet. But it has the amount of water and when it was originally started. But what's really cool is on each ditch, it has a map and it shows that surface flow. So if you those hot links are pretty vital to you when you get that. So just so you know. So our next question is, what happens when the water right is granted when the land was federal territory? Wouldn't that make it federal right? The amount of water granted in winters has a reflection in the surface of the reservation and the use of it. What's the importance that the court usually gives to ADWR purpose adjudication, and what kind of presumptions does it give to surface water? Do you think I need you for that? Yeah, let's do it. You want to come on up?
So the first question is, if the land was granted when the land was a federal territory, does that make it a federal right? No. The Winters Doctrine applies to when the federal government sets aside land for a purpose. That's the federal government's purpose. So national park, Indian reservation, military base, a federal activity or purpose. Second one, the relationship between the amount of water and the surface area, I think, is what's being asked. And there has long been this rule in the Winters Doctrine that the amount of practicably irrigable acreage within a reservation is a very important guideline for how much water has been reserved for those tribes. So there is a connection, but it's not actually the area of land, because you can imagine that there might be massive, and to some extent this is true of the Navajo reservation. It's a very large reservation. The proportion of land within that reservation that's actually irrigable, meaning that you could farm it, is small compared with, for example, the Gila River Indian community near Phoenix, where pretty much every square inch of the reservation could be farmed. That's why they were there, except for the river, which flows through it. So there's a relation, but it's not a direct connection. And the final thing is, what's the role of ADWR? So the Department of Water Resources is our water regulatory agency. It's not our only water agency, but it's kind of like our water supply regulatory agency. And they're the technical expert. They have a team of hydrologists and other water experts who work for, almost like the technical expert, like the expert witness for the state of Arizona. And so they're asked by the court, come up with the de minimis, how we determine a de minimis use. And they'll do a big study, they'll take suggestions, as Carter talked about, and then they will produce their final determination.
Who was it that asked that question? Would they stand up? Are they still here? Okay, we're going to move on. Linda's going to have our next question in the audience.
I'm curious if you can provide some insight into SRP's motivation for having de minimis use based on the percentage of usage during the critical period versus the annual usage, as well as the potential impact on the outcome of the situation if it were to be recognized that way.
Okay. So you're referring to, thank you for the question. It relates to the de minimis standard that is currently being evaluated by the court. And the reason for choosing the June low flow as the basis for looking at water availability, which are among the 4 factors. That's only one of 4 factors that feed into the de minimis determination. Carter, can you flip to that, maybe to that slide if we... well, maybe we're doing something else here. Okay, so that's one of 4 factors, is water availability. We think using water availability in the month of June is the most important or the best way to do it, because that's when the river is unable to satisfy its current right holders during that time. That's when the impact of well uses are being felt by surface water users. And I don't just mean SRP, I mean the surface water users in Cottonwood, in Camp Verde, and Oak Creek, because that's when the flows are at its lowest. And that's why you need to look at those months, why you have to look at that month, rather than an annual that tends to wash out the impact of that. What's the impact of de minimis, the de minimis standard? As Carter's slide mentioned out, it's largely a case management decision. It's not, the de minimis decision does not say, if I can get a de minimis process, then I'll be able to get a water right for my well. It's really about, how does the court best use its time? Does it best use its time by having a summary adjudication process for small uses, or does it involve a full-blown adjudication for those small uses? So the court may find a cost benefit to continue to still do a summary adjudication, or what we would say a de minimis adjudication. That really is, there are only a few things you may need to show But they're important things like, does my well have a basis of right? Do I have a pre-1919 use? Those are important things that even with a de minimis process, you still have to show and demonstrate as a well user.
Thank you. I understood you to say that SRP purchased a ranch down in Camp Verde and that the stated purpose was to help people with their water rights. Then you bought another ranch. Just wondering why one wouldn't have worked.
Yeah, hello? Okay. All right. I think it's just the amount of historically irrigated, or historic water rights or potential claims that are there. The one property yielded approximately 70, the other property yielded about 100. So I guess the thought was just that we can't do much with 65 or 70 acre feet. You know, if we're going to do this program, let's try to do it so it can have an impact. I think that was it.
Lucas was involved in the beforehand portion of that, so he might know
Yeah,
more.
I'll also add that the continued use of those, until those water rights are severed and transferred, is to keep it in its current use, which is agriculture. We currently lease the farms today, and will continue to do so. Even as we begin severing and transferring from those areas, it'll just be a reduction in the amount of agriculture on those properties until such time when it makes sense to likely develop those properties as a way to pay back. That was the commitment we made to our board, is to pay back our investment in those properties. It's not to make any money off the program. This is a break-even scenario. It's not a money-making thing for us.
Okay, wait just a second, Linda. Okay, I think the next one's going to be for you, Sarah. The chip plant in Dove Valley area and the large data center storages in the East Valley require large amounts of water use. We have not heard about how they prove their source of the water use. What data do you have to share?
So I want to, so the chip plant that I think this is referring to is the new Taiwan semiconductor plant that's being built in an area otherwise known as Biscuit Flat. That is on land that the city of Phoenix acquired from the state lands department. And when Colorado River water was being handed out, the state lands department got some so that when cities took state lands, that's kind of been part of the plan, there would be water to go with it. So that's the water that's going to be the water for TSMC. While a lot of water goes into the plant to be hyper purified to create semiconductor chips, something like 85% of the water can be reclaimed and reused. So it is not that high in terms of water consumption. I've never run the numbers, but it's probably comparable to craft beer. Anyway, but dollar for dollar, it probably produces much higher paying jobs and brings much more revenues into the economy. Data centers are really interesting because both Chandler and Mesa have enacted ordinances that effectively discourage high water use data centers. They make it a lot harder for high volume uses that don't provide a big return to the cities. And so just yesterday, Google announced that they're building a big new data center that will be completely air-cooled. The only water being used is the water, in the bathrooms and the break rooms. So basically, those plants typically go into the municipality who's going to be the water provider, and they say, we're going to be a new high-volume user of water. Can you guarantee us that you're going to be able to provide us that water? And it's up to the city. It's their water portfolio. The ratepayers in that city have made the investments in that portfolio. And so it's really up to that particular community to decide how they want to allocate the water in their portfolio. But I think we're seeing some very positive changes in that kind of commercial and industrial use of water.
Not done with you yet, gal. This next one's for you. What is the possibility of a new landowners to get surface water rights from the Verde River?
So the surface water right, as Lucas said, runs with the land, and it doesn't matter if you just bought the land. If it has a very old right, then you'll get that right. It just depends on when the water right was established.
I have heard that there are certain, hello? Okay. I've heard that there are some small towns in Arizona, I think this was in the White Mountains somewhere, that are currently already experiencing difficulties in supplying municipal water. Can you speak to that and maybe let us know where this is happening?
What is the question?
Are there areas in Arizona that are having water supply
Sure,
problems?
sure. The biggest kind of challenges that we're seeing, I would say, are up in the northwestern corner of the state, like Kingman area, where they've seen they're a groundwater-dependent community, and they've seen an influx of large-scale agricultural operations that are causing them to be very concerned about the availability of groundwater in the long term. But there are problems here and there, but we don't have big cities on the verge of running out of water in Arizona at all.
You guys want some more questions answered? It's a little after 2. Show of hands? Okay.
So just a question. Obviously, there's been an adjudication process for Gila River area already, and apparently the coming is the Yavapai Apache Nation. So if that, from the history of that process, which is fairly current, is there when that happens, when the adjudication is finished, is there usually a reduction in the rights available to, say, SRP or other stakeholders once those settlements have been reached with those tribes, and how does that affect, smaller claimants, smaller right holders? Is it everybody equally reduced? Is there a negotiation process that happens between the different parties? There's this process right now going on between SRP and small claimants to kind of say, hey, we won't disagree later. Does that disadvantage those smaller users because they've already said we won't argue with you when it's all done?
So there's a lot packed into those several questions, but let me just make a couple of mentions of tribal water rights settlements and how they typically go. Tribal water rights settlements are an important part of the adjudication process. Arizona's been really good at entering into a lot of tribal water rights settlements. There's still many tribes that don't have settlements, one of which is in the Verde Valley community, the Yavapai Apache Nation. SRP and other parties are working to negotiate a tribal water rights settlement for Yavapai Apache Nation with the nation, with the United States. And ultimately, the Verde Valley communities will have an opportunity to weigh in on any settlement that is proposed. So they'll have an opportunity. Those tribal water rights settlements have to be approved by the adjudication court. So there's a court process to approve those settlements. So any objector who's a party in the adjudication can weigh in on tribal water rights settlements. So they'll have an opportunity to do that. In terms of where the water supplies come from to meet the tribal water rights settlements, as Sarah mentioned earlier, a lot of tribal settlements have been built on Colorado River water through the CAP Canal. That's how a lot of them have been done. There's been others, like the White Mountain Apache Tribe settlement in eastern Arizona, that are more based on local resources. So it's not a hard and fast rule that it's all Colorado River or all others. What ends up happening is that the parties involved in those, the parties that feel like they have a stake in it, participate and sometimes contribute water to those settlements as well. So sometimes, yes, it does involve a reduction. Those settlements often end up resulting in lower quantities as claimed by the tribal entity as well. So what the tribe claims today is often less than what they will get through settlement. What they get through settlement is infrastructure dollars through the federal government to build things, to put that water that they have a right to, that they settle for, to use. Anything else?
Good job.
Next one on the screen. How are regional hydrological maps assessed? Accessed.
Do you want, so there, you can go to the Arizona Water Blueprint, that's where I would start. If the person is asking about the hydrological surveys that the Department of Water Resources does in the adjudication, go to azwater.gov, go to programs, go to adjudication, and then you'll see the interactive maps, and there's some fantastic interactive maps on that website.
You had mentioned about if you are in a certain area of the map that shows that your surface water, you're essentially considered that you're pumping surface water. Does the depth of the well, so let's say you dig and you hit water at 100 feet, but you decide to take your well to 400 feet, does the depth of the well within the surface water area of the map have any determination on whether you're considered pumping surface water or groundwater? I have a second question.
It doesn't have any bearing on whether you're within the jurisdiction or out of the jurisdiction of the court. It may have some bearing on whether or not you're pumping appropriable surface water or not. That would be what the depletion test would show.
And then second question, I hear we're talking about there's adjudication with the tribal waters, which is federal, which trumps, it doesn't matter, it's not first in use, that trumps everything. So that's one adjudication. And then we have SRP that is involved in another water rights adjudication, which is first in use, essentially, is what if I'm understanding correctly. If we're filing claims in that, or a claim for water, do we have to file separately for each one of those, or do you file one claim that then encompasses all of this?
It's one proceeding. It's the one adjudication. And just to be clear, federal water rights do not trump seniority. There are special attributes of federal water rights that make them stronger. You don't have you don't have the use it or lose it problem. Federal water rights can include groundwater. So there are some things that make them bigger and stronger, but it still is a matter of seniority. So if the federal government reserves land, and the date of that reservation is after let's say the Salt River Valley Users Association got their rights decreed in 1910, that later reservation does not have a senior claim. It's just a federal claim has more attributes that make it kind of a stronger water right. All happening in one adjudication. You can find everything you need at azwater.gov.
Shared well. Does everybody on that shared well file statement of claim, or just the well owner manager?
I won't venture a guess as to what to do with shared wells. They're very complex. I would suggest reaching out to ADWR on what to do there.
Previously, they had told us, go ahead and file more papers.
That's what I would do. Err on the side of filing.
Okay, whether we want to or not, one more question because the event center has somebody else waiting. So if you have further questions, just text them to 928-900-3506, and I'll make sure they get to these guys when they're busy, and they can email me back, and I'll text it back to you. Okay, one more.
Yes, this is regarding the great example of when realtors are presented with acreage. I think it was an example of 70 acres, and they then subdivided. And you, in the first green area was pretty okay. The second green area, or the second orange area where they added on, still was in better condition. But what if they stopped using the water, let's say 15 years ago, because the owner passed away and it just let it sit there? What happens to that use right? Is that impacted anyway? Does that make sense?
Yeah, so it's a very complex answer that probably requires an attorney to answer it. But let's just say there are some provisions in state law that says if you don't use water, that after a certain period of time you could lose it. That's not a universal statement, but there are situations or circumstances where, yes, you can lose it if you don't use it.
Sorry to say this, I got to kick you guys out. Thank you so much for coming.
Thank you.
And hope you learned something today. I sure did. Thanks a lot.